welcome. We have our next seating is Ronald Meisburg. I won't call you by the name that your mom used to call you. Gabriel Semmel and Peter Kirstenau. How you doing, Pete? Good. Joseph Fargo Spencer. No. Oh yeah, that's right. We got to switch around. Yeah. Okay. Tom Micklejohn, of course. How are you, Tom? Yeah, okay. And Kara. Kara, can you pronounce your last name? Because is that C a hard C or soft C?
It's Maciel.
Maciel. Okay, wonderful.
M-A-H sound, right.
Thank you all. Okay, Ron, why don't you proceed?
Thank you very much, Mr. Chairman, members of the board. I am still Ronald Meisburg, and I'm still here on behalf of the United States Chamber of Commerce. The topic for this panel involves the standard to be applied in scheduling an election. The board has asked each witness to address specific questions, which we will do. But first, I want to set some context for my remarks. The board states that its proposal is necessary so that employees' votes may be recorded accurately, efficiently, and speedily, and to remove unnecessary barriers to the fair and expeditious resolution of questions concerning representation. But we do not believe the board has articulated why the current system is not expeditiously resolving questions concerning representation. As the Chamber and many others have pointed out, and as members Ms. Camara and Johnson had noted in their dissent, the NPRM advocates a cure that is not rationally related to the disease. The statistics on the efficiency of the board's excellent representation case handling under existing procedures is well known. 92% roughly of all elections are held pursuant to an agreement. For all cases, the median time between the filing of a petition and an election is 38 days. 94% of all elections occur within 56 days. And if you focus on the cases involving pre-election hearings, as members Ms. Camara and Johnson emphasized in their dissent, in 2013, the median time between the petition and an election in those cases was 59 days. Now, looking at the statistics, it's difficult to understand how these differences justify the board's proposed broad rewrite of election rules. The Chamber agrees with members Ms. Camara and Johnson that the data demonstrate that delay is an issue confined principally to a discrete minority of less than 10% of all representation cases. The graph that was published with their dissent at 79 Fed Reg 7346 dramatically illustrates that the cases in this small discrete group, the less than 10% of all election cases, creates a tail of cases in which elections were conducted from somewhere between 57 to over 3,000 days. Now, clearly, that tail is where the board should focus its attention, and as dissenting members suggest, closely examine the particular reasons that have contributed to those relatively few elections that have involved unacceptable delay. Now, with the board's own statistics showing the lack of a need for these broad proposed changes, we now turn to the specific issues posed by the board. First, we want to address whether the proposed rules adequately protect free speech interests. It's been indicated that the proposed rules may reduce the time for the scheduling of an election to roughly less than half the median time of 38 days for the holding of elections under the current system. This threatens to seriously undermine the rights of employers and employees recognized under the First Amendment and 8C by the Supreme Court to engage in a free and open discussion on the issue of union representation and collective bargaining. As I noted yesterday, unions have months or even years to plan to organize the workforce before the employer may ever be aware of it. They file election petitions at the time of their choosing, and many, if not most, employers are ill-prepared to immediately respond to the arguments and promises made by the union in the preceding months. Because of these concerns and others, the Chamber proposes no change be made in the current system employed by the Board in representation cases. We believe that the current system adequately protects the free speech concerns of all. You ask us what standards should be applied for scheduling an election. We do not believe there should be any change from current practice. The 92% of elections held under an agreement between the parties and are conducted in an expeditious manner. The agreements presumably reflect bargaining trade-offs agreed to by the parties and the regional offices. What better way to resolve the competing interests and desires of the parties than by an agreement arrived at voluntarily? The same is true with respect to the 8% of cases in which a hearing is held. Although not the product of an agreement, the elections involved there were the product of an orderly and generally expeditious hearing process, as the board's own statistics demonstrate. There's no need to change the current system with respect to these cases, at least for those that are within or near that 59-day medium time frame. To the extent that any election extends into the tail of cases that go beyond the median, at less than 10% of all cases, the board should study those cases. If it does so, it can, in that process, solicit the views of its constituencies regarding whether, as soon as practicable, or some other standard or formulation is appropriate for scheduling an election in those cases. Finally, we are asked to specify whether the rule should include a minimum or maximum time between the filing of the petition and the election, and how long that time should be. Because we do not believe there should be any change in the current system, we also do not believe there should be any change in the time frames that are the product of the current system. Instead, if the board studies the outlier cases in the tail, it can, in that process, solicit the views of its constituencies regarding whether there should be minimum and maximum times applicable to those cases, and if so, what those times should be. Thank you.
What about that 25 days for a request for review? What do you think about that?
We did not take a position on that in our formal comments, other than to say that we don't think that the review should be eliminated.
Mm. Well, if we okay, I'm sorry, go ahead.
So if there is a time that the regional directors are going to be given routinely to account for that review, obviously that is up to the board. But I'm not prepared today to agree that that would be the proper thing to do. If we were at the beginning of this process, as we had suggested might be more appropriate, where I could sit down with my client and others and you to discuss how that might be handled, I think that would have been a good thing. But at this point, I think, on behalf of my client, we're not prepared to sort of stipulate to any sort of changes or differences that the board hasn't proposed, other than to say we believe that the current system works appropriately, that in fact review should be maintained as it currently is, and that the board should focus its energies, and a considerable amount of energies, in studying the outlier cases and focus on those in order to obtain the reasons for the delay in those cases and what the appropriate changes might be to stop the delay in those cases.
Now, speaking as a former general counsel, wasn't it your position that the board should embrace processes that would expedite or provide opportunity for free choice in a more expeditious manner?
Well, first of all, with all respect, I'm not speaking on behalf of myself or in any personal capacity or former capacity. I'm speaking on behalf of my client, the Chamber of Commerce. I think, what I recall as general counsel as being the most efficient thing was that, and it runs a little contrary to some of the testimony we've had, our system of regions is kind of a federal system. And while we worked very hard to maintain consistency across the regions in what constituted an unfair labor practice, what was illegal, I believe we tolerate a lot more in the cases of, well, when are we going to schedule an election? And how are we going to deal with the parties? And the reason we do that is because there's nothing legal or illegal about it. It's much more based in over 90% of the cases, what the parties themselves can come to agree to. But when that's not the case, it gives the regional directors some freedom to deal with. I think we've acknowledged today there can be tremendous differences in each case, and there are even differences among the regions simply because of local customs, because of I remember Region 1 celebrates Patriots Day. They don't do it everywhere else. In New Orleans, they take off Fat Tuesday, I think, and say, so you have these kind of regional differences. And you have differences in the employers in these regions. So I really think the current system can be accommodated very well to doing what you want to do, which is eliminate delay, but eliminate delay where it is bad, not where it's really not delay.
I'm thinking that a Fat Tuesday proposal in the NPRM is an omission.
I second the motion.
Right.
Mr. Meisburg, you're a former general counsel and a former board member, and former member Kirstenau is with us as well. Is there anything that would prevent, and would you oppose anything that we could do as a board if we get a request for review? I mean, one option, which I assume we won't go back to, is just to have the board directly address all representation election issues, which was the case before the early 60s. But is there anything that would prevent us, in connection with requests for review, to adopt a different way to address those cases? And, you can take almost any kind of alternative dispute resolution process that has been suggested for different kinds of tribunals, and there are many varieties that could result in quicker decisions by the board. Is there anything that would prevent us from doing that if we get a request for review and deciding that more promptly?
Well, first, let me say what impelled the legislative enactment in the LMRDA that allowed the board to delegate some of this to the regional directors at the time was a huge backlog. I'm not so sure that today, that would be seen as necessary. And I do think the board's involvement in the election process is key. I really don't think we can farm this out to the regional directors completely. Even though I think for purposes of the arranging the election, that we regional directors should have a fair amount of the discretion that they currently exercise. As to the second part of the question on the issue of what other resolution processes might be available, or could the board introduce a resolution, I have not and will not speak on behalf of my client as to that issue, but let me just say on behalf of myself personally, I don't see, since the board has introduced settlement judges and other processes to settle unfair labor practice cases, that it would be beyond doesn't seem like it would be beyond the board's authority to run a test program of some sort like that. And that's without commenting on the efficacy of the program itself, but it seems like the board has taken that power in other types of cases, so I don't know that I can see a legal impediment to it. I stress that this is not something that I've had a chance to discuss with my client or any of its members, and so I can't take a disposition on their behalf, but that's what I think.
Thank you.
Really quickly, you're one of the only 5 people in U.S. history who have actually served as a board member and general counsel, and I think that makes your contribution here invaluable. And our ultimate mission is to separate out unnecessary delay from necessary delay, so we can basically render justice. And I think you've covered at least making sure the board should be directly involved in the representation procedures as part of what you would see as some necessary delay. From your perspective, what are the necessary delays in the process? Why are they necessary? I know you don't have a lot of time, so just broad brush it.
Well, certainly there is a delay necessary to provide due process and free speech rights. That's very important to the Chamber. We've made that a part of our written comments as well as a part of my oral presentation today. I think the delay that accommodates legitimate interest of the parties in a given setting that we can't possibly know what the facts are, subject to the regional director's ability to guide the parties, and in some cases direct the parties to an election. You know, regional directors, their compensation, I don't know how it is under the current budget, but they were rated every year. And they were rated in accordance with certain standards and the goals that the board sets for, you know, conducting elections, so many elections within so many days and handling other things. Regional directors have every incentive, personally, in terms of compensation, to try and meet those goals. And in as many cases as it is possible to meet those goals. In as many cases as it is not necessary to delay meeting those goals. So they're going to make that judgment in the first instance, and we believe that right now they're doing a good job. We don't know much about this, whether the delay in the tail I talked about, you know, maybe the delay in the case that was the election was held on the 57th day is necessary delay. Maybe the delay that was involved in the election that was held on the 3,000th day involved some necessary delay and some unnecessary delay. The fact is, we don't know, because we haven't put the lens of study on that outlier group of cases. So I certainly think there is necessary delay, the due process and free speech concerns, and I know we've heard earlier the educational concerns, which is a factor of that. There may be other necessary delays that will show up in given cases that we just can't know about. But we certainly see where the group of cases is that kind of would fit the research pattern for where the unnecessary delay may be lurking. And I think that's where the board should focus its efforts.
Thank you.
Thank you.